Hello friends, Namaskaram. Myself is Dr. Jinesh Soni. I am an advocate and a corporate lawyer. In today's class, I will discuss the important guidelines of Honorable Supreme Court which could help you to secure acquittal in a case under Prevention of Corruption Act. If you really want to learn and want to update your information, I request all of you to maintain a proper notebook along with pen or pencil so that you could maintain your information in the proper format. First of all, we have to note down the name of judgment. Judgment name is Mini versus CBI. Citation is 2025 INSC, page number 980. Now we are coming on the facts. In that case, the accused was convicted under Section 7, 13, Subclause 1, Subclause D of PC Act, read with Section 13, Subclause 2 of PC Act. When the proceedings were occurred, the accused was working as lower division clerk at passport office. The complainant was in need of passport on urgent basis, and that's why complainant communicated at passport office, and finally he met with the accused. It is a case of complainant that the accused demanded rupees 1000 towards a legal fee and rupees 200 towards bribe, and it is agreed that rupees 100 will be paid in advance and remaining amount will be paid when the work will be done. At that time, complainant shows his inability to pay the amount and later he arranged the amount. In the meanwhile, he submitted a report to the law enforcement agency. Finally, the proceedings were conducted and accused was caught red-handed. In the case at hand, the Court of Session convicted the accused. Even the appeal against conviction was rejected and order of conviction was upheld by Honorable High Court. And finally, the petition was filed before Honorable Supreme Court for vindication of the grievances. It is a case of the accused that the prosecution failed to prove the offence beyond reasonable doubt. To sustain the argument, following points are submitted. Please be noted. Number 1, complainant turned hostile. As we know that demand is sine qua non to prove the offence under Section 7 of PC Act. If demand is not proved, even though there is a recovery from accused, the same could not be a ground to sustain prosecution. It is a case of complainant that the accused demanded the bribe. But the key point is that there is no eye evidence in the case to corroborate the said version. And apart from that, the complainant turned hostile. If complainant turned hostile, in that scenario, the demand could not be said to be verified and corroborated. As we know that in multiple judgments, Honorable Supreme Court is of view that even the sole testimony could be a basis for conviction. But if the testimony is inconsistent, in that scenario, the adverse inference could be drawn against the prosecution. So if in your case, the complainant turned hostile, in that scenario, you may rely on the said judgment titled as Mini versus CBI. Citation is 2025 INSC, page number 980. Point number 2. As we know that demand is required to be proved. If demand is not proved, in that scenario, the prosecution could not be sustained. Point number 3. In the case at hand, the statement of the accused had been recorded as per Section 313 of CRPC. Even the accused has given the proper explanation of the incriminating evidence, and that's why it is a fit case to draw inference against the prosecution as submitted by the accused. Please be noted, if you are an accused under Prevention of Corruption Act, you are required to give the proper explanation of the incrimination, even in the statement under Section 313 of CRPC. Do not take the statement under Section 313 of CRPC as a mere formality. It might cause prejudice to you. Point number 4. the complainant had suppressed the material fact. It is submitted by the accused that the complainant communicated through an advocate with the accused to get the passport on urgent basis. Subsequent to this, the complainant had come to the house of accused along with documents and processing fee of rupees 1000. The accused was totally unable to have information of the fact that along with the said amount, he mixed the bribe amount. And that's why when the money was taken, suddenly the team members had come, and finally it is said that the accused was caught red-handed. It is submitted that the said explanation is sufficient to rebut the presumption as wrongly drawn under section 20 of PC Act. Because the accused is not bound to prove the defense beyond reasonable doubt, he is totally bound to give the plausible explanation of the scenario. That is called probable defense. So if the probable defense is given and it is indicating of the fact that the implication of the accused in the wrong case is evident in that scenario, accused deserves a benefit. So finally, Honorable Court concluded the case that demand is not proved. In absence of demand, mere recovery and acceptance could not be a basis to convict the accused. And apart from that, if accused is succeeded to raise the plausible explanation or probable defense on the incriminations in that scenario, the accused deserves a benefit. So we have to understand the fact that whenever we are having the recovery or acceptance from us, in that scenario, we are required to give the plausible explanation of the scenario. If we fail to give the same in that scenario, the court may draw the adverse inference against us as per section 114, subclause Z of Indian Evidence Act. But we have to be alert on that point that we are not supposed or required to give our explanation beyond the reasonable doubt. Simply, we have to create the circumstances that may create a doubt in the case of prosecution. For example, the money is recovered from you. You may raise a stand that it is not recovered from you, and inter alia it is shown to be recovered from you. For this, you are required to produce the defense evidence. Apart from that, you may take the theory of thrusting of money. So in this way, we may create a doubt, and if doubt is created and it is apparent to be correct, in that scenario, the presumption of section 20 of PC Act is rebutted and the accused could be succeeded. So I think that I am totally able to enlighten all of you about the recent legal position concerning the prosecution under section 7 and 1320 of PC Act. So whenever you are having such prosecutions and you want to defeat the prosecution, you have to make your own path, but it must be supported and corroborated with the legal principle. So we have to work out simply on demand, acceptance, recovery, the proper explanation of the scenarios, and apart from that, we have to emphasize on our statement to be recorded as per the protocol of section 313 of CRPC. And apart from that, we have to consider the point of sanction also, whether it is cyclostyled or genuine. If all the circumstances are duly hit by us or duly countered by us, then definitely we could be succeeded in our case. So there is no need to worry. Simply work on your case and definitely you will be succeeded. See you in the next topic. Till then, Jai Hind, Jai Bharat.